Good afternoon, Mr. Langholz. Welcome.
Good afternoon.
Good to see you today. So as soon as you're settled and ready, you may begin with your opening statement.
Thank you, Ms. Roberts, members of the Commission. For a small-town boy from Clear Lake, it's a real privilege to be here today, humbly asking for your nomination to serve as Iowa's next Supreme Court Justice. I still get goosebumps every time I walk into this building, just as I have that same sense of awe each morning walking into the state capitol across the street to serve Iowans. I think it's because the dignity and strength of this building reminds me that as public servants, we're part of something much bigger. Iowans built these buildings to stand the test of time, just like they built our Constitution to endure. And those of us who are blessed to have the opportunity to serve are just stewards, whether that's in the executive branch, legislative branch, or judiciary. And it would be the honor of a lifetime to be able to continue that stewardship on the Iowa Supreme Court. But rather than dwelling on all of the reasons that I would love to serve in that role or stepping through my diverse professional background, I'd like to spend a few minutes of our time together talking about what sort of Supreme Court justice I would be. I would be steadfastly committed to the rule of law. I would be impartial and open-minded, and I would never forget that we're deciding cases of real people who need a fair process. And these aren't empty promises or just aspirational goals for me. You don't have to take my word for it. If you want to see what sort of Supreme Court justice I will be, you only need to look at what sort of judge I was when I led the Administrative Hearings Division for 4 years. With a great group of colleagues, we worked to develop a culture focused on these goals, and I practiced them myself in my cases. And I want to talk about a few of those here with you today as some concrete examples. So first of all, I'm steadfastly committed to the rule of law. As ALJs, we often heard compelling stories from Iowans. Iowans who wanted to have their food assistance benefits continue so they could feed their families, who wanted medical care for themselves or their loved ones, wanted to keep their driver's license so they could continue working. But no matter how compelling that story was, it was our duty to follow the law, even if we didn't like where that took us as a result. Justice Scalia famously said, and has been quoted by others, that a judge who likes the result in all his decisions is a very bad judge. And there were certainly decisions that I did not like my result in. But one example of sort of how I approached following the law, is the case I attached as a writing sample, a young man who had his license revoked because he had prescription drugs and a little bit of alcohol in his system. And he presented testimony from his doctor that all the drugs in his system were from his prescription, and that his doctor said he was okay with the doctor, you could safely consume alcohol. And so he wanted to rely on the prescription drug defense in that case and not have his license revoked. There certainly were some interests of fairness and some policy concerns with that, but the problem was the statute didn't allow it. The statute said if there was any presence of alcohol, you couldn't use the prescription drug defense. And so in that case, I did not allow it. I followed the law, and I would approach things the same way on the Iowa Supreme Court. Perhaps I'm old-fashioned, but I think that Iowans should be able to pull their code books off the shelf or pull it up online and rely on the texts in that code. When judges interpret the code to create new exceptions based on their ideas of the purpose of the statute or policy, the words on the page stop to be as useful and meaningful for people. But when courts remain firm to the text, then the process works, because if Iowans are unhappy with that, their legislature will go back and change the law so that going forward, the law is on the code books in the page is the way consistent with the will of the people. And that's the way the process should work. So, second, I am also impartial and open-minded. And this comes pretty naturally for me. Ever since I've started my professional career, I found that I'm naturally, more objective and want to come to the right results in the case. That's one of the reasons you won't see in my background a long period of being a trial advocate, trying to push the law in one direction or another for my client. I have trouble that doesn't come as naturally to me. I discovered when I was an ALJ that I had found my calling being in a judicial role. And a case that, but even so, as natural as that comes, I still was mindful that I needed to be constantly vigilant, to be open-minded. Because as you get going into a case, sometimes your mind starts to close. You start to think you're smarter than the parties, or you start to like the result that you're coming down, or get proud of your work. An example of this for me was a case I once had that was kind of complicated. It involved a business that was going to have to pay a sum to the state, and it involved math, which as a lawyer was not my forte. So I left the math for the end of the case. I relied on the parties' assertions of the math, did some estimates, and started crafting my decision. Unfortunately, when I got to the end of the case and started doing the number crunching to do the math that I had postponed, it turned out my estimates had been wrong, and that the math didn't work out. A number that needed to be positive was negative, and the whole logic of my case collapsed. And so for an afternoon, I was tempted. I found myself, I come to like the result in this case, and I was trying to figure out some other way to ignore the facts, or to come up with a way to still reach that result. But after clearing my mind with a walk around the Capitol complex, I concluded no, I needed to follow the law. I needed to, with integrity, apply the law to the facts as they were. And I scrapped most of that decision, wrote a decision the other way, and proceeded as things were. And again, that's how I'd approach things on the Supreme Court. From the moment a case comes into my desk, throughout the briefing, the researching, the oral arguments, circulating of drafts with my colleagues until it's published, I'd be keeping an open mind with the single-minded goal of getting it right. So third and finally, I will never forget that these cases, no matter how legally significant, involve real people that need to be treated fairly and feel like they're treated fairly. People need to be respected and heard and understand what's happening to them. Research tells us that process matters, that in fact sometimes it matters more than the result in the case, and that in criminal contexts, criminals are less likely to recidivate when they feel that they have been involved with a fair process, or in civil contexts that they're more likely to comply with court orders. And that flows through, people talk about it most of the time at the trial level or at the ALJ level, but that flows through up to the Supreme Court. And again, for me, when this was really driven home, was a case that I talk about in detail in my application. But you might remember a woman who wanted to be a foster care parent. And by asking one more question at the end of a 40-minute hearing, I was able to discover why this woman, who had 6 criminal convictions, some of which were pretty serious, and 2 founded child abuse assessments, thought she should be a foster care parent. She told me that she'd been adopted as a child, and that she wanted to give back, and that she realized she had had a troubled history but thought she'd turned a corner. And she told me that she was afraid and embarrassed to be going through this process. But now, after the hearing, she was glad that she did so, and she thanked me. So by taking that extra 4 minutes, I was able to write a more compassionate decision that respected her, that made sure she was heard, and then explained why she could not be a foster parent at this time. And again, I'd approach things the same way on the Supreme Court. I would dig into reading the briefs and the record with a goal of understanding. I'd approach oral arguments in the same way, of understanding and respecting the parties and their attorneys, and thinking about how we can make that as positive experience as possible. And then ultimately, when writing a decision, with a goal of writing clearly, concisely, and I think you've seen my writing from my writing samples, but writing for the public as well as the parties so they understand what has happened to them. The other thing that case reminds me, and really kind of my whole 4 years working with the ALJs, is that the most important judicial officer in any proceeding is not the Supreme Court justice who's writing that appellate decision, or his or her colleagues. It's the district court judge, district associate judge, probate judge, juvenile judge, magistrate judge, or administrative law judge who's sitting in front of the parties, giving them their fair hearing, their fair day in court, and a fair process. And I will never forget that as a Supreme Court justice. Because of that, they need the support of the Supreme Court. They need an open ear for eager to hear about improvements and sharing of best practices around the state. The Supreme Court, ideally, on the case side, is just the afterthought that ultimately, provides guidance to the court going forward and correction from time to time. At bottom, I think perhaps the sort of Supreme Court justice that I would be can be summed up in the words of the judicial oath that I hope someday I'll have the opportunity to take here in this room, that I'll support our constitutions, that I will without fear, favor, affection, or hope of reward, to the best of my knowledge and ability, will administer justice according to the law, equally to the rich and the poor. If you see fit to nominate me, and I'm fortunate enough to be appointed to the Supreme Court, I will live those words with every fiber of my being, and I'll strive every day to fulfill the trust that you've placed in me. Thanks for your consideration, for your time and effort in this process, and I look forward to your questions.
Thank you. And we will begin with Mr. Sukup.
Thank you. Good afternoon, Mr. Langholz.
Good afternoon.
What experiences would you bring as head of the state's public defender's office to the court?
I loved my experience in the State Public Defender's Office. I think it's prepared me in a number of ways. First of all, it's given me a perspective on the criminal justice system that was eye-opening to me, understanding the challenges of criminal defense attorneys and especially public defenders, who don't get to choose their clients, who are there in a core part of the criminal justice system. I think it would be especially helpful with respect to matters of judicial administration and understanding that the decisions that the Supreme Court makes, both in their case decisions, but also in matters of policy within the judicial branch, affect ripple across, affecting state public defenders, the corrections system, the parole board, and an understanding that it's important to really involve all those stakeholders in the process. The other really significant lesson I learned from that is how different the practice of law is all around the state. The public defender system has offices all around the state. I got to hear sort of a boots on the ground perspective, on a daily basis as issues would bubble up to us. So rather than just sort of, and I tried to get out to the state as much as possible as well. I love to visit the offices and courthouses and get to see how things were going. And I think that's really important for the Supreme Court to remember as well as you're going about, especially matters of judicial administration.
Thank you.
Ms. Valentine?
Thank you. Somewhat of a follow-up to that, it's my understanding that while you were in the public defender's office, there were changes made in terms of additional CLE requirements for to handle juvenile court matters, as well as requiring specific jury trial experience I think it's 5 jury trials to handle a felony, and jury trial experience to handle a misdemeanor. I'm curious what you think the impact of those changes are in terms of access to justice, particularly in rural counties where court appointment work used to be how young lawyers got their teeth, done to get trial work, which that's just not happening anymore in rural counties.
Mm-hmm. Well, I'm proud of the efforts that we did, in a number of ways, including those to try to improve the quality of representation in juvenile cases. The juvenile requirements were the part of a lengthy task force that actually I co-chaired with now Chief Justice Christensen that looked at parents' representation and engaged in stakeholders from around the state. The criminal justice requirements, sort of which were going on a parallel track at the same time, was a group of stakeholders that I pulled together of criminal defense attorneys and other law professors and others involved in the system. We tried to craft a balanced approach that still left open. The requirement to do misdemeanor cases was very low. In my recollection, and it's been some time since I've looked at those, but my recollection is that for misdemeanor cases, essentially there's an introductory class that the state public defender's office offers consistent with when the bar exam is admitted each year to provide a path for attorneys that want to start getting that experience, but leaving some of those serious cases, because it was a real problem. We heard, and again, this is something. It's hard to come with a one-size-fits-all solution across the state, because this varied in states, or varied in counties. But in some counties, like Polk County, where the list of contract attorneys is tremendously long, we were hearing about people who had were just out of law school getting appointed to a Class B felony or a Class C felony, and we would hear from attorneys in our office or other contract attorneys appointed to co-defendants about pretty serious problems involved in those cases. So the goal was to come up with a gradiated structure. I have not followed as closely all of the ramifications since then. I do know that the number of contract attorneys has dwindled or has reduced since then, and there are parts of the state, especially rural Iowa, where that's a serious problem. I think it's a problem beyond just indigent defense, trying to figure out how we're going to ensure that there is legal representation where it's needed throughout Iowa. I think perhaps the Supreme Court can have a role in being a leader or a convener of people to think about that. There's probably a role potentially from a legislative standpoint as well to be looking at some of those issues as also.
Thank you.
Mrs. Sinclair.
As Dorothy said earlier today, I'm going to address the elephant in the room. And as you know, there's been a groundswell of comment saying that your appointment would reduce the appointment to a political one instead of a merit one. What do you have to say to that?
Well, I trust that this commission is going to do its job, that it's going to evaluate all of the candidates based on their merit, based on the applications, based on the letters of recommendation with respect to me, particularly those letters that came in from people who know me, who have worked with me, and I trust that this commission is not going to make a political decision, that it's going to pick 3 nominees that will be qualified to serve on the Iowa Supreme Court, and I trust that.
Ms. Conover.
To follow up on that, Mr. Langholz, the Commission has received dozens of letters expressing concern that given that you are currently serving in the governor's office as senior legal counsel and special advisor to the governor, that your appointment would detract from the independence that our judicial branch needs. Is that a relevant consideration for this commission? Could you address that?
Respectfully, I don't think it is. I think your job is to consider the applicants that have been submitted or that have put themselves forward to serve Iowans, to decide which of those applicants are the 3 best nominees to serve on the Supreme Court. And I don't think it's disqualifying to be currently serving in another role. This is something that I thought about before deciding to apply. It's something that happens, all around the country. I found, I'm sure it's not an exhaustive list, but at least 16 examples just in the last 10 years of governors that have had current staff move to the judiciary. Some of those have been in states with commission systems like these, where the staff apply to the commission evaluates them, sends them as a nominee if they are qualified to serve, and in some cases then those individuals have gone on to serve in the Supreme Court. And it's not been a problem in the other states. I recognize that the role, my role changes. I'm not here today as a representative of the governor's office. In fact, I'm on vacation right now. I will be taking a new judicial oath that I talked about that is moving into an entirely different role that's required to be fair and impartial. I recognize that. I can understand why people who don't know me, who have had a political operation, ginning them up to be writing into you, might be concerned about that. But I'm confident that if I am fortunate enough to be nominated and appointed, my work will speak for itself, that I abide by the judicial oath, and that I won't be showing favor towards the governor or the state or any other party.
Thank you. Mr. Berger?
No questions.
Mr. Goodman?
No questions, thank you.
Mr. Bloom?
Well, the hardest thing I had evaluating, because I do look for a lot of private practice experience. You had a very good law school, valedictorian or tied in your class, good federal clerk, great law firm, Davis Brown. You were there a relatively short period of time. I would have liked to have seen that longer. So your application was unique in that I didn't really understand what exactly your role was. I knew about the state public defender, and I didn't understand much about the Department of Inspection and Appeals. But you had a letter written by Ann Wise, who's the director of Louisiana Division of Administrative Law, and she said, consider the great value of Sam's experience in the administrative judiciary, the People's Court. Sam developed critical judicial skills, managing a caseload that impacts citizens' day-to-day lives, and refining the judicial decorum and temperament necessary with the public and the bar. So this is a person with 18 years of experience, apparently doing a very similar role, and she's imploring us, all of us, to consider the importance of that. And that was meaningful to me because I just really didn't understand the importance of it.
And for response, I'd like you to be very brief. We are over time. Sorry to interrupt, Mr. Bloom.
That's fine, thank you.
Well, I appreciate those comments, and I appreciate any kind things that Ann said. She was a great colleague nationally, one of many people I got to know.
Thank you. Thank you.
Thank you.
Mr. Langholz, thank you for being here, and we wish you well.
Oh, no, that's fine. I knew I was too short for that question.